So oral arguments were heard in the California magazine ban case Duncan v. Bonta. This case is growing ever more in importance because every other California two-way case that is before the Ninth Circuit is now on hold until Duncan is decided. So let's talk about what happened during the arguments. But real quick before we jump into this video, if you think that magazine capacity restrictions does in fact violate your Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you guys know that we now have Armed Scholar merch. So a lot of you guys were asking for t-shirts and other things like that. We do have that. I'll put a link down in the details section in the comment section to merch if you want to pick yourself up a shirt or something like that. So Duncan v. Bonta, formerly known as Duncan v. Becerra, is a case that has been in the works for quite a while. Just a quick background, this is a challenge to California's magazine capacity restrictions under California Penal Code 32310, which pretty much makes it illegal for you to buy, sell, import, manufacture, or possess any magazine that holds more than 10 rounds. There was a challenge to this in the Southern District of California before Judge Benitez. He found that this law was unconstitutional. It went before a 3-judge panel in the Ninth Circuit on appeal. That 3-judge panel also found that California's law was indeed unconstitutional, and the state of California still didn't like that decision, so then appealed the decision en banc, which is before an 11-judge panel review in the Ninth Circuit. And that is what has happened. That's what we're talking about here in this video, is the oral arguments that happened before that 11-judge panel in the Ninth Circuit. Now, why this case is so much more important now, that is because, like a lot of you guys are aware, maybe some of you aren't aware, pretty much every single California two-way case or two-way case in the Ninth Circuit that the Ninth Circuit is supposed to be reviewing is now on hold until Duncan is decided by the en banc panel in the Ninth Circuit. This includes Miller v. Bonta, which a lot of us were anticipating and hoping for another Freedom Week. Miller v. Bonta deals with the ban on so-called assault weapons in the state of California. And now Rupp is on hold until Duncan is decided. On top of that, you also have Rode v. Becerra, which deals with ammunition restrictions. And that one is also on hold until Duncan is decided. So you can see how Duncan v. Becerra and the oral arguments here and everything that's going on is so much more important for all these other cases that are now on hold. Now I'm going to give you my main takeaways after watching the oral arguments before the en banc panel. And really this can be put into 4 main categories: the types of questions that were being asked and the types of arguments that were occurring. Now, the first category goes to the type of analysis that should be adopted here in this case, whether it should be text, history, and tradition under Heller in the Supreme Court's decision, or tiered scrutiny, which the Ninth Circuit has traditionally used. The second category of questions fell mainly on the issue of common use and possession for lawful purposes, so there was a lot of questions that were asked about that. The third one dealt with the reduction of mass shootings and the interest that the state is alleging for the basis of why they need this magazine capacity restriction. And the last category dealt with the takings clause and wasn't as big of an issue, but was still brought up by Judge Waterford and was asked of both the state and the plaintiff. So when it came to the type of analysis, there were some questions asked to the state's representative, who weirdly looked like either Pennywise the Clown or maybe even Reno May, but I know it wasn't Reno May because he says he's not an attorney, but maybe he's lying. I'm just kidding, Reno. We all saw your post and I thought that was hilarious. But yeah, the state's representative was asked a lot of questions about the type of analysis that should be applied. So for example, some questions came from Judge Nelson, and he actually stated that Heller did not use tiered scrutiny. So where is the state getting this from, and where is the Ninth Circuit getting this from? And the answer was from essentially First Amendment jurisprudence and importing the First Amendment jurisprudence into the Second Amendment context. But pretty much in Judge Nelson's questioning, he stated that that type of analysis is incorrect and that Heller should be used. And so that kind of gives you some insight in at least to what Nelson is thinking as far as that text, history, and tradition should be used instead of the tiered scrutiny that the state of California wants to use. And then looking at text, history, and tradition during this questioning, you even heard the state of California say that some of the evidence put forward was that the puckle gun that existed prior to the Second Amendment could fire more than 10 rounds. They state that that was just a novelty, which was later retorted actually by plaintiff's counsel, who said, well, they're leaving completely out the 1866 Winchester rifle that shot well over 10 rounds and was widely distributed, sold, and used in the US. And so this whole history behind what the state is saying that these types of firearms didn't exist is just incorrect. Now, leaving the whole type of analysis that should be used, the next main type of questions that were asked had to do with common use, common possession for lawful purposes, and a lot of questions were asked of both the state and also were asked to the plaintiff's counsel. Here in these questionings is really where you saw where most of the judges were going to lean in their argument, in my opinion. For example, when you looked at the questions asked by Judge Berzon, she asked the state questions of whether or not common use had to do with actual possession of magazines that hold more than 10 rounds or actual use in self-defense. So she was pretty much kind of giving a softball to the state of California. And of course, the state of California took that and they said, well, common use is in fact actual use. It is not possession, which was retorted by plaintiff's counsel and saying, no, that's not what this is. It is actual possession of magazines, and it is the possession of these magazines, your right to keep these magazines, which is protected. Now, I thought some of the most critical and thought-provoking questions were actually asked by Judge Van Dyke, and he actually pressed the state of California's representative quite a bit on the issue of rarity and actually exposed a lot of the ridiculousness behind this law in the state of California. The state of California relies heavily in their arguments on the fact that the data that they have say that you only have to use 2.3 rounds on average to protect yourself, but Judge Van Dyke said, well, it's just as rare that you would even have to defend yourself at all with a firearm, so what then would preclude the state of California from just outright banning firearms altogether, let alone 2.3 rounds, when the odds are that most people don't even need to defend themselves in their lifetime. And then he also pointed to the fact that then they actually are kind of using rarity in their favor, and it's kind of the heads we win, tails you lose analysis that the state is engaging in. They're saying it's just as rare that you would have to use 2.3 rounds to defend yourself, but it's also super rare that mass shootings happen, but we should be worried about them. So they're kind of using rarity on both aspects. And even more so in this section, it exposes the state's argument that they relied on heavily of that, you don't need magazines of more than 10 rounds because you can simply reload or you can use another firearm to defend yourself. You don't need to have more than 10 rounds to adequately defend yourself. And they even said quite a bit of times that, well, my friend on the other side never presented any evidence that someone needed more than 10 rounds, or actually, in fact, what they were stating is that they used a 10-round magazine, reloaded, or used another gun, and ultimately that led to them maybe losing their life or something like that. They were saying that there's no evidence of that. But on the other side, what they're also arguing is that the public interest here in restricting magazines is that it causes assailants or criminals to have to reload, which gives you an opportunity to then escape or defend yourself or stop that individual. They're saying that that is the public interest behind actually having a magazine limitation. But that runs also against your right to self-defense, because if they're saying that someone who is using 10-round magazines will have to reload and then you have an opportunity to escape or stop them, doesn't that also apply to your individual right to self-defense and you having to reload? Isn't then there a greater opportunity for whoever is engaging in criminal activity against you, stopping you, escaping, harming you because you're engaged in reloading? Again, you can see on the rarity issue how the state kind of has this double standard and uses and double dips on the rarity. And then also here on this aspect, they are double dipping as well. Now, when it came to common use for lawful purposes, I think this is where plaintiff's counsel failed quite a bit and made some really bad arguments that I think a lot of you, if you watched, were upset with. And mainly that is, there were questions asked, for example, by Judge Hurwitz, where he said, well, if you can have magazines of more than 10 rounds, where is the limit where maybe the state could actually limit the type of magazines you could have? What would that be? And the plaintiff's counsel said, well, maybe 50 or 60. I think we all could agree, is what she said, that those magazines are indeed high capacity, and maybe the state has an interest in actually restricting and people aren't using those in self-defense, and that the marketplace actually doesn't show a desire of the public to actually possess and use those types of magazines with 50, 60 rounds, whatever. In this section, I was just simply not a fan of those arguments that the plaintiff's counsel was putting forward, because again, this case here has to do not just with those standard capacity magazines that come, for example, in your Glock, your 15 rounds, 19 rounds, whatever it is, but it has to do with any magazine over 10 rounds. That includes those 50 rounds, those 60 rounds, your 100-round drum magazines. It includes those magazines as well. So here the plaintiff's counsel was actually conceding kind of an aspect of this case. I just didn't like those arguments that were put forward here. Now, moving on to the other main category of questions that were asked, it had to do with the stated interest of the state of California in reducing mass shootings, and that is the whole rationale they're putting forward in actually having a magazine capacity restriction in the state. Judge Hurwitz asked the state of California, well, what evidence do you have, and that the state is relying on that magazine capacity restrictions would indeed reduce mass shootings or maybe even the lethality of these types of shootings. And the state of California said, well, we had an expert who looked at some of the data and found that it does reduce so-called mass shootings, which again, mass shootings is a weird term that includes a lot of things, including common crime of more than, I think it's 3 or more individuals being actually injured in a shooting, but it's not the mass shooting that you see all the time on the news. But those numbers are actually inflated, which was retorted by plaintiff's counsel and saying, well, those numbers aren't necessarily correct and were opposed by our expert. Here in this section about reduction of mass shootings in the state's public interest, plaintiff's counsel was asked a question by Judge Van Dyke. He asked about that whole rarity issue again and the rarity of mass shootings having occurred in the U.S. And plaintiff's counsel had a good response here in relation to DC v. Heller and that outright ban on the possession of handguns. She stated there in Heller that the Supreme Court found that an outright ban on something commonly used for lawful purposes, despite the fact that the handgun is most commonly used by criminals or whatever the rationale there in DC was, it didn't override the fact that these are arms that are kept and bared by law-abiding individuals for lawful purposes protected by the Second Amendment. So pretty much those few bad apples don't override everybody else's right, which is an argument we make all the time, that just because someone engages in criminal activity, that doesn't strip everybody of their rights. Now, the last main section of questions came in regards to the takings clause, and this was mainly asked by Judge Waterford. He was kind of the judge that took up the whole takings clause issue. He said that it's unlikely that the court will reach this, but he had to ask it anyways to see what the response of the state was, as well as the plaintiffs. Of course, the state's reaction was that they do not believe that this is a takings, that people could easily modify these magazines that maybe hold more than 10 rounds to 10 rounds. They said that you could reference a website and do it in simply minutes by yourself, which is actually interesting because the state of California does not actually have any firm guidance on how you can adequately or actually appropriately modify magazines to permanently be fixed. So they're saying that this is not a takings because you can modify it, sell it, take it out of state, destroy it, turn it over, all of those things. They're saying you have alternatives, so this isn't a takings. But one of those main ones there is modifying, and the state of California never actually has given any guidance. Well, they had guidance and then they removed it, but there's not actually any guidance on the book about how to actually do that appropriately without becoming a felon. And the plaintiff's response to this whole taking issue relied a lot on some case law in regards to the state saying you either have to turn over raisins or convert it into wine. There was also some analogies drawn about, well, this is like saying you have 2 houses, you destroy one, but you get to keep one, so that's not a taking. Plaintiff's counsel here said that actually having to restrict, let's say, a magazine capacity from 30 down to 10, although you get to keep that 10 round capacity, it's still a takings because you're destroying half of your property. Now, one of the questions that I'm sure I'm going to be asked after this video and that I should just address here is the fact that a lot of people are already asking, well, when will the Ninth Circuit make its determination in this case, Duncan v. Bonta? Really, my response to that is your guess is as good as mine, but I can give you some general guidelines based on like recent cases that we've had before the en banc panel. For example, Young. So when you look at Young, the oral arguments before the en banc panel were heard September 24th of 2020, and then the opinion came March 24th of 2021. So that's about a 6-month turnover for them to actually issue their order in that Young case. So you're looking at maybe 6 months, maybe more. It just depends. But again, that maybe should give you some general guidelines. And mainly, I think people who are asking that question, they're expecting a really quick turnaround on this decision. And the simple fact is it is not going to be a quick turnaround. It is at least going to take some amount of months for the en banc panel to actually issue their order. So hopefully that gave you guys some insight on the Duncan v. Bonta case. And like I said, this case is growing even more in importance because all these other cases are now on hold until this case is decided. I will also put a link to the oral arguments down in the detail section if you want to watch it in full for yourself. It's about an hour long. So if you want to watch all the questions that I've referenced here in this video, you can definitely do that. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability, or you can just comment down below to fuel the algorithm. Make sure you like to fuel the algorithm. Make sure you're subscribed to fuel the algorithm, because all of that signals to YouTube that people see value in this type of two-way news, and it will push it more to those individuals who maybe aren't hearing this type of stuff but do want to hear it. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.